5 seconds to go. Start. Learned counsel submitted that when relevant law is ignored and an inapplicable law forms the basis for foundation of the judgment, it would be a ground of review. In this regard, learned counsel relied upon decisions of the Supreme Court in the matters of Dev Narayan Singh versus Daddan Singh 1986 supplementary SCC 530, Shri Uddhav Singh versus Madhav Rao Sindhia 1977 1 SCC 511, Jagannath Temple Managing Committee versus Siddha Mutt 2015-16 SCC 542, Yashwant Sinha versus CBI 2022 SCC 338, and Mamaleshwar Prasad versus Kanhaiya Lal 1975 to SCC 232, Municipal Corporation of Delhi versus Gurnam Kaur 1989 1 SCC 101. Learned counsel submitted that the division bench had erred in applying the test of Article 14 in context of Rule 59 of the Rules of 2010. It is submitted that erstwhile employees of non-government aided educational institutions cannot be placed in the same class as that of the existing government servants. The rules of 2010 for the first time created a new dying cadre with its own special features regarding eligibility, promotion, career, advancement, gratuity, etc., and the said employees of non-government aided educational institutions forms a separate class altogether and cannot contend that they should be given the pensionary benefits at par with the existing government servants, whereas even the government servants who are appointed on or after 1st January 2004 are also not entitled to the same benefits. Rather, for the purpose of pension, they are governed by the rules of 2005. Learned senior counsel submitted that the validity of Rule 5 of the rules of 2010 had already been upheld by a division bench of this court at Jaipur, wide order dated 25th January 2018, passed in Prem Prakash Purohit and others versus State of Rajasthan, DB Civil Writ Petition number 61 of 2013, which has not been noticed by the division bench while passing the order under review, and thus the review petition deserves to be allowed on this count alone. Learned counsel submitted that if the correctness of the earlier decision of a coordinate bench is doubted, then the only course open for the subsequent bench is to refer the matter for consideration to the larger bench. In support of the contention, learned counsel relied upon a decision of the Supreme Court in Central Board of Dawadi Bohra Community versus State of Maharashtra 2005 to SCC 673. Learned counsel further submitted that the division bench has failed to appreciate that the appointments accorded to the writ petitioners were the fresh appointments under the rules of 2010, and they have already received full and final settlement of the dues under the Act of 1989 and the rules of 1993 from their respective aided institutions, and thus it would be incorrect to apply the rules of 1996 to the employees appointed prior to 1st January 2004 and extend benefit of pension for the period of service already covered under the Act of 1989 and the rules of 1993. Stop.